Happy New Year, or as I've been saying alternately, Happy Not 2020. This is the January 6th, 2021 Land Use Commission meeting, and it's being held using interactive video conference technology, linking conference participants and other interested individuals, including members of the public, via the Zoom Internet conferencing program. And we're doing this, of course, to comply with state and county official operational directives during the COVID-19 pandemic. Members of the public are viewing the meeting via the Zoom webinar platform. For all meeting participants, I'd like to stress to everyone the importance of speaking slowly, clearly, and directly into your microphone. Before speaking, please state your name and identify yourself for the record. Also, please be aware that all meeting participants are being recorded in this digital record of the Zoom meeting. Your continued participation is your implied consent to be part of the public record of this event. If you do not wish to be part of the public record, you should exit the meeting now. This Zoom conferencing technology allows the parties and each participating commissioner individual remote access to the meeting via our own personal digital devices. Please note that due to matters entirely outside of our control, occasional disruptions to connectivity may occur for one or more participants of the meeting at any given time. If this happens, please let us know, and then please be patient as we try to restore audiovisual signals to effectively conduct business during the pandemic. For members of the public who are participating during via telephone, if there are any, and I will repeat this instruction when it's time for testimony, but you can raise your hand using *9 and then use the same keystroke *9 to virtually lower your hand if you're calling in by phone. If you want to test that out and do that, you should feel free to. If your hand is raised, you can use *6 to mute and unmute. My name is Jonathan Likeke Scheuer. I currently have the pleasure and honor of serving as the LUC chair. Along with me, Commissioners Axon, Chang, Okuda, Wong, our LUC Executive Officer Daniel Ordenker, our Chief Planner Scott Derrickson, our Chief Clerk Riley Hakoda, our Deputy Attorney General Colin Lau, and our court reporter for the day Rita King are all on the island of Oahu. Commissioner Nancy Cabral is on Hawaii Island. Commissioner Ohigashi is on Maui, and Commissioner Giovanni is on Kauai. We currently have 8 seated commissioners of a possible 9. As we'll discuss later, we received well over 50 written testimonies submitted on this docket. And so I'm just going to say a few words if this is in case you're tuning in to your first LUC meeting ever and you're not sure who we are. The LUC was created by the state land use law, Chapter 205, Hawaii Revised Statutes, which was originally adopted in 1961 and established a framework of land use management and regulation to which all lands in the state of Hawaii are classified into one of 4 land use districts. To administer the state land use law, the legislature created this Land Use Commission composed of 9 members, and we are all appointed by the governor and confirmed by the Senate. 1 member is appointed from each of the 4 counties and 5 members are appointed at large. And for members of the public, our confirmation means that if you don't like what we're doing and we're up for reconfirmation, you can testify and say, I don't think that you should confirm that person to the position. Or alternately, if you think we're doing a good job, you could say that as well. With that, I'm going to ask move to our next agenda, our first agenda item, which is adoption of the minutes. The minutes are not actually ready. I just want to check with Mr. Hakoda or Mr. Derrickson if any testimony was submitted regarding adoption of the minutes.
Mr. Chair, this is Riley. There was no public testimony and we apologize for the minutes not being ready, but circumstances over the weekend and the bomb scare yesterday delayed us processing the minutes. Yeah, our apologies.
No, we fully understand. Sorry for that. Thank you very much. So we will defer action on adoption of the minutes till our next meeting. Our next agenda item then is our tentative meeting schedule. Mr. Ordenker.
Thank you, Mr. Chair. Tomorrow we have scheduled any matters that are not resolved today with regard to HoKua Place by Zoom. On January 28th, we will also be holding a meeting by Zoom on the Barry Trust matter, as well as on February 10th. And on February 10th, we will also be picking up the U of N Bencorp matter, requesting us to be accepting authority for environmental assessment. On February 11th, we will have an informational briefing on the IAL, Oahu IAL submittal. February 24th and 25th, we will take up the IAL submittal. On March 10th and 11th, we will once again be taking up the HoKua Place matter. That's before us today. On March 24th and 25th, we will again take up the Oahu IAL matter. On April 14th, we will be taking up.
Mr. Oradenker, sorry, just the simultaneously turning of pages by you and Commissioner Wong is being picked up very heavily on the mics.
Arnold.
I'll stop.
And on April 14th, we will be taking up a declaratory ruling requested in Maui County.
Thank you very much. Commissioners, are there any questions for Dan? Okay. If not, our next agenda item is an action regarding docket number A11-791, HG Kauai Joint Venture LLC, HoKua Place. Petition to amend the land use district boundary of certain lands situated at Kapa'a, Island of Kauai, State of Hawaii, consisting of 97 acres from the agricultural and rural district to the urban district. Tax map key number 4-3-03, a portion of lot 1. To consider Liko Okalani Martin's motion to continue the contested case hearing dates for docket number A11-791. Will the parties please identify themselves for the record, beginning with the petitioner?
William Ewan on behalf of petitioner.
Okay. Kauai County.
Good morning, Commission. Deputy County Attorney Chris Donahoe on behalf of the county.
Thank you. Office of Planning.
Morning, Chair and members. Deputy Attorney General Donna Puna on behalf of the State Office of Planning. Here with me is Rodney Funakoshi.
And interveners.
Aloha, good morning. Oh,
Go ahead, Lance.
sorry. Good aloha and good morning. This is Lance Collins together with Bianca Isaki, and Mr. Martin is also present this morning.
Thank you. Good morning to all of you. Before we continue, let me update the record on this docket. On December 3rd, 2020, the Commission met via Zoom to consider intervener Liko Martin's petition to intervene. On December 10th, 2020, the Commission received the County of Kauai's position statement in this matter. On December 14th, the Commission received the intervener's notice of appearance of counsel, the intervener's motion to continue the contested case hearing dates, as well as the intervener's motion for leave to file a response to the applicant's motion for a protective order. On December 16th, the Commission mailed the order granting the intervener status for intervener Martin's petition to intervene. On December 29th, the Commission mailed the agenda notice of our January 6th and 7th, 2021 meeting to the parties, to intervener Martin, the statewide email and Kauai mailing lists. From December 9th until recently, and possibly through this morning, the Commission has received approximately 65 or more emails, as well as written public testimony on this matter. They are being made part of the record and are being posted to the website once they are cataloged and received by the staff. Before we continue on, I'm going to ask, are there any disclosures on this docket from any members of the Commission? If not, the chair has a disclosure. If you recall, at our hearing where we granted intervener status to Liko Martin, I very strongly encouraged Mr. Martin to secure outside counsel, even though it wasn't strictly required under our procedures to do so. So perhaps in the case of be careful of what you wish for, I was surprised to then learn that colleague and friend Bianca Isaki was secured as his counsel along with Lance Collins. I noted above their appearance was filed with the LUC on December 14th, and I saw their notice of appearance the following week. Based on my understanding, I do not have, nor have I had, a financial interest with Ms. Isaki as is defined in the state's ethic code. But I want to explain and be really clear for everyone the current nature of our relationship. I made substantially the same disclosures when Ms. Isaki represented 2 clients before us on the Kanahele matter, DR 1967, except for my third point, which has arose since in the fall of 2020. I've used Ms. Isaki as a subcontractor to me on 2 contracts, with those contracts ending a couple of years ago. One was with the National Park Service and one was with the Department of Hawaiian Homelands. She and I have co-written a book together, which is to be published in 2021, entitled Water and Power in West Maui. And finally, my third point, she and I have been in the part of an early negotiation of a new contract with me as a primary and her as a potential subcontractor. We've been advised by the potential client that the contract may be finalized in March or April of 2021, if selected. Now, my belief is I can be fair and impartial on the matters before the LUC in this docket, A11-791. And I hope that the parties and my fellow commissioners will not object to my participation. But that said, I want everybody to feel absolutely clear to object. And procedurally, here's what I'll do. I will ask any of the parties. If there's no objections, we'll continue. If there is an objection, I will hand the chairing to Nancy Cabral to resolve the objections. I'll start with the petitioner, Mr. Yuan. You are on mute, Mr. Yuan.
Mr. Chairman, you said you're negotiating another contract with Intervenors Council?
I have been approached on doing some contractual work, and I had indicated in that process that I would use Ms. Isaki as a subcontractor. That's correct.
So is there any financial interest between you and Ms. Isaki?
No, not under the meaning of the term in the state ethics law.
Okay, fine. I have no objection then.
Thank you. Kauai County.
Thank you, Chair. Deputy County Attorney Chris Donahoe. Given your responses to Mr. Yuan, the county has no objection as well.
Okay, thank you. Office of Planning.
OP has no objections.
Okay. Intervenor.
We have no objection.
Okay. Commissioners. Okay. Thank you very much. Now let me briefly review our procedures for today's docket, which I will consider the motions to continue the contested case hearing dates, as well as the intervener's motion for leave to file a response to the applicant's motion for a protective order. Depending on the outcome of the intervener's motion for leave, the commission may or may not move forward on the applicant's motion for a protective order. First thing we'll do is call for individuals who desire to provide public testimony on this docket to raise their hands and identify themselves. For everybody who's listening in as the attendees, and I see there's 14 members in attendance right now, I want to assure you of a few things. First of all, I'm positive my fellow commissioners have read all the written testimony that's been delivered to date. When I reviewed them late last night and early this morning, all of those were very clear pieces of testimony, all opposed to the substance of the matter of the primary docket before us, not directly related to what our matters are today, the motions before us. So we are today going to ask you to limit your testimony only to the motions before us. Again, the intervener's motion for continuance, the intervener's motion for leave to file responses to the applicant's motion for the protective order, and the applicant's motion for protective order. After that testimony is done, if any, Ms. Isaki and Mr. Collins will make their presentation in support of the intervener's motion to continue the contested case hearing dates. After Ms. Isaki's presentation and Mr. Collins will receive the argument of the argument on the intervener's motion to continue from the petitioner, from the county, and the State Office of Planning. After all parties have presented their arguments on that motion to continue, The commission will conduct our deliberations and possibly render a decision on that motion. After that, after the commission has decided on the intervener's motion to continue, we will hear the intervener's presentation in support of their motion to leave for file response to the applicant's motion for a protective order. After their presentation in support of that motion, we'll receive argument on the same from the petitioner, the county, and the State Office of Planning. After that, the commission will deliberate and possibly issue a decision on the motion for leave. And following that, it is possible that we could also decide on whether or not and decide on the applicant's motion for a protective order. Are there any questions on our procedures for today, starting again with the petitioner?
No questions, Mr. Chairman.
Kauai County, Mr. Donahoe.
Thank you, Chair. No questions.
Okay. OP,
No questions.
interveners.
No questions.
Okay, thank you. We're now in the portion of our agenda item for public testimony. If there's any members of the audience who wish to provide public testimony on this matter, either use the raise your hand function on the Zoom software or press *9 if you are dialing in by phone. And I will then bring you into the meeting and swear you in. Are there any members of the public who wish to provide public testimony on this matter? Seeing none, I will repeat that there is extensive public testimony that has been received by the commission, has been incorporated into be part of the public record, and is being posted to the commission website. With there being no public testimony, I'm going to move on to the presentation by the intervener on their motion for, let me say it correctly, their motion for continuance. Who will be presenting, Ms. Isaki or Mr. Collins?
Mr. Chair, I'll be presenting the argument on behalf of the intervener.
Please proceed, Mr. Collins.
Thank you. Chair and commissioners, we are seeking to continue the schedule of hearings and filings as presented in the written moving papers. All of the dates were agreed to by the other parties before Ms. Isaki and I entered our appearance. We, as noted, just were retained last month, and having a small additional time to prepare would be greatly appreciated. And since all of the parties agreed before we were retained, no other party would be prejudiced by the continuance of the dates.
Okay.
Thank you.
Okay. Are there questions for the intervener from the commissioners? Seeing none, Mr. Yuan, your response.
No objection to the motion.
Okay. Mr. Donahoe.
No objection by the county.
And Ms. Apuna.
No objection to the motion.
Okay. You know, I don't want to botchy this, but we are rocketing along here. Commissioners, I believe we can move on to deliberation on the motion of the intervener. Before we do, I will actually ask just so it's clear on the record and for all the participants, Mr. Ordenker, can you clarify the dates for us that we're talking about?
Thank you, Mr. Chair. Right now, and I would need clarification from the intervener. These are the dates that we currently have for the various filings and hearing dates. January 25th, 2021 for filing of witness and exhibit lists. February 10th, 2021 for filing of exhibits and including OP's and county's testimony. February 17th, 2021, rebuttal witness and rebuttal testimony for all parties, and March 10th and 11th hearing dates.
So I'm going to ask all the parties to confirm those are your shared understanding of the dates.
Petitioner understands those dates.
Okay.
Chair, the county understands those dates as well.
Okay. OP
Yes, OP, those dates are correct.
and intervener.
Yes, Chair, those are the dates.
Okay. Anything further on this issue, Mr. Ordenker?
No, Mr. Chair, that clarifies everything.
Okay, great. So commissioners, I will entertain discussion and a motion if so inspired to do so.
Chair, this
Commissioner Wong.
I move for the adoption of the motion.
Okay.
Granting.
Oh, granting of the motion, sorry.
Commissioner Wong has moved to grant the motion. Commissioner Giovanni is seconding the motion.
Move to second the motion.
Okay. Commissioners, we are in discussion to grant the motion filed by the intervener.
Chair, real fast, this is Commissioner Wong.
Commissioner
Just
Wong.
everyone agrees upon it, so that's why I'll be supporting and made the motion.
Okay. Commissioner Giovanni, do you wish to
Same.
say anything?
I feel the same way. I like to see people agree.
Yes. Anything, any discussion, commissioners? Okay. Mr. Ordenker, will you please poll the commission on the motion?
Thank you, Mr. Chair. The motion is to grant the motion for continuance of dates. Commissioner Wong,
Aye.
Commissioner Giovanni,
Aye.
Commissioner Axon,
Aye.
Commissioner Cabral,
Yes.
Commissioner Okuda,
Yes.
Commissioner Ohigashi,
Yes.
Commissioner Chang,
Aye.
Chair Schreier.
Aye.
Thank you, Mr. Chair. The motion passes unanimously.
Okay. Our next agenda item, our fourth order of business, is the intervener's motion for leave to file a response to the applicant's motion for protective order, and will follow the same order of presentation. I will ask the, well, I'll just ask Mr. Collins to begin, or Ms. Isaki, as it may be.
Thank you, Mr. Chair. We filed this motion for leave to reply so that the argument on the primary motion would be more orderly, and that all of the parties and the commissioners would have adequate notice of the arguments that we are going to make today. Mr. Martin was admitted as a party the day after the due date to file a response, and we felt by providing in writing our argument and seeking leave to have it accepted, it would provide all of the parties with our position for the primary motion today, and that no party would be prejudiced by allowing this to be filed, and also that nobody would be surprised by the arguments that we would otherwise make if the written reply were not accepted.
So if I may start the questioning, Mr. Collins, is the entirety of your argument, written argument against the applicant's motion for protective order contained in the exhibit to your motion, or are you asking for additional time to do additional written?
No, we're simply asking that the proposed reply be allowed to be filed, and just saying that we felt that it was more orderly to do that as opposed to showing up today and then just stating everything verbally, so that everybody would have a fair chance to go through the authorities and so forth, and it wouldn't be a surprise.
Thank you very much. Commissioners, questions? No questions from the commissioners? This is the same commission I've been serving on for years, isn't it? Okay. If not, then let's hear from Mr. Ewan.
I have no objection to the motion.
Okay. Mr. Donahoe.
Thank you, Chair. The county has no objection to intervener's motion.
Okay. Office of Planning.
OP has no objection to intervener's motion.
Commissioner Wong?
I have nothing, Chair.
Oh, okay. I saw you reaching for the mic button.
No, it was to reach for my candy.
Oh. Okay. Mr. Ordenker. Are there any points that you want clarified on where we are procedurally now?
Oh, Mr. Chair, I believe we're,
Sorry?
no, Mr. Chair, I don't
Okay.
need any clarification, further clarification.
Okay. So, if
Mr.
I
Chair,
may, yes.
do we
Mr.
need to
Lau.
take public testimony on this?
When I announced public testimony, I had announced that we were taking public testimony on any of the 3 motions that are listed on the agenda that may be considered.
Okay.
I'm happy to ask again, is there any member of the audience who wishes to give testimony on this particular motion that's before us? And for the person who is participating by phone, you can raise your hand using *9. Otherwise, you raise your hand using the raise your hand function in Zoom. I see none. Thank you very much, Mr. Attorney General. I'm going to actually ask for a quick 3-minute recess at the discretion of the chair. It's 9:27. We will resume at 9:30. With the indulgence of it's 9:29. I will start formally in a minute. With the indulgence of the parties, there was an item placed in the question and answer from a participant who either does not have access to or cannot find the raise hand function. So I'm going to bring them in and ask them to clarify whether or not they're seeking to give testimony on this particular narrow issue of the intervener's motion for leave to file a response to the applicant's motion for a protective order, rather than on the substance of the entire document. A docket, excuse me. So I'm going to allow Ms. Ragush to talk before admitting her. If you can unmute yourself, Ms. Ragush.
Thank you.
So we are on, I don't know if you were at the beginning of the hearing.
Yes, I was.
So we're not discussing the substance of the pros and cons of the overall petition by the petitioner for reclassification. We're merely discussing right now the intervener's motion for leave to file a response to the applicant's motion for a protective order. Did you have testimony you wanted to deliver on that?
Yes, please.
Is there any objection from the parties for this late testimony?
Petitioner has no objection.
County?
County has no objection, Chair.
OP has no objection.
Okay. Interveners?
No objection.
Okay. Ms. Ragush, I will give you 3 minutes, and I ask you again to keep it narrowly focused on the matter before us. Please proceed, stating your name and address for the record to begin with.
Thank you, Commissioners. My name is Rain Regish. Address is 5820A Halakahiki Place, Kapa'a, Kauai. So again, good morning. Apologies for the glitches with Zoom. So my testimony is related to this motion for a protective order specifically. And over the course of many years, the public's interest in this project has been significant. And many of us question whether the petitioner has the economic ability to carry out this proposed development. This particular project deserves the highest degree of public transparency. And I hope you'll find that there is no legitimate basis to approve.
Ms. Ragush, if I may, I'm just going to note for the record that your testimony appears to be not actually with the matter that we're about to enter deliberation on, which is the intervener's motion for leave to file a response, but actually possibly on the petitioner's motion for protective order itself, which we have not yet decided whether or not we're going to consider today.
All right,
I just wanna make that-
apologies.
I just want to
I
make
had
that
to-
clear. I will let you continue, but I want to make it clear that you're not speaking directly to the matter that's in front of us.
Should I postpone this testimony until the motion for a protective order?
It's up to
Or
you.
the-
I'm going to leave it up to you since you've started, but I just want to clarify what's going on here.
All
Please
right,
continue.
and again, my apologies. It's because I've signed on several times. I think I missed something during those gaps.
No problem.
So I will continue. I hope the commissioners will find that there's no legitimate basis to approve the protective order that the petitioner is requesting. The public interest in disclosure far outweighs the privacy interest of this petitioner, and the required standard for a higher level of confidentiality has not been met. And full transparency gives the public access to financial information, which helps them assess whether or not they're capable of undertaking this high density development.
Okay.
So please deny the petitioner's request for protective order. They have not met the burden of proof.
Thank you. Thank you. Are there questions for the testifier from the party, starting with the petitioner?
No questions, Your Honor, Mr. Chairman.
Thank you.
No questions by the county, Mr. Chairman.
No questions from OP.
Commissioners? Oh, sorry, intervener.
No questions.
Commissioners? Okay. I will note for the record, also due to the sort of unusual sequencing of this, I didn't swear in Ms. Regush. Ms. Regush, was the testimony that you just gave the truth?
Yes, it was.
Okay, thank you.
Thank
Any
you.
other questions? Okay, thank you for your testimony. I'm going to move you to be an attendee again. Okay, commissioners, we have a motion before us from the intervener who's explained why they filed the motion to make their arguments known to the other parties. Is there consideration of the motion? Does somebody want to take that up? Commissioner
Mr.
Chang.
Chair? Yes, sorry, I can't seem to find the raise hand function either.
Oh.
Can I ask a procedural question?
Yes.
I appreciate that the intervener actually included an exhibit of their argument and that all the other parties have no objections to the intervener's motion to file a response on the protective order. This is a question procedurally. Are the other parties, specifically the petitioner, requesting time to respond to the motion, to the petitioner's motion? I'm just not sure procedurally how we're going to proceed
Okay.
once we take action.
So there's both a procedural legal aspect to that as well as a scheduling aspect of that. I'm going to actually ask Dan Ordenker to respond first on the scheduling aspect of that, and then Mr. Lau to follow on, as well as any thoughts from the parties. Dan, starting with Dan.
From a scheduling standpoint, the hearing on this protective order, we could hear if the parties are not prepared to move forward today, and we have not had a request from any of the parties to, in writing at least, to postpone the hearing on the motion for protective order. If the parties feel that we need to move the date for this, if they need additional time, then we can hear this matter on January 27th. But I would question the parties as to whether or not that is actually necessary.
Sorry, anything to add, Mr. Lau, before we hear from the parties?
Not really, other than that the intervener's already said that he doesn't intend to file anything in addition, so perhaps that could be filed as of today if the motion is granted.
Yeah, okay. Mr. Ewan?
We do not require additional time.
Okay. Mr. Donahoe?
The county is not requesting additional time.
Okay.
And no objection to the commission accepting the attached exhibit as the intervener's response.
Okay.
OP has no objection to I'm sorry, we don't require any additional time to reply.
Okay. I believe we've heard from the intervener on this matter, but okay. Commissioner Chang?
No, that I greatly appreciate the cooperation of all the parties on this matter. It appears that there is no additional arguments to be added by the parties other than what's already been filed. So I guess we can proceed on the intervener's motion to file his response and then move forward on the next motion. So thank you very much, Mr. Chair.
Okay, so thank you. Yeah, so my understanding is what we can do is we can consider this motion, and if it's granted, we can then decide whether or not to just move into the consideration of the motion today, or we could alternatively, the commission could say we want to take it up on the 27th, but that can come next after granting, if this motion is granted. Commissioner Wong?
Sure, I would like to move for the adoption of this motion.
Okay. There's a motion for adoption by Commissioner Wong. Is there a second? Commissioner Cabral seconds the motion.
Chair, if I may speak on this, my motion.
Sorry, can I just get an oral confirmation? Commissioner Cabral, I saw you raise your hand, but yes,
Yes,
you're
I am
seconding?
seconding
Okay.
Commissioner Wong's motion. Thank you.
Motion has been made by Commissioner Wong to grant, seconded by Commissioner Cabral. Commissioner Wong wishes to speak to the motion.
Yeah, first off, all the parties agree upon this motion, so that's why I'm make for the push for the motion. Also, I just want to say also the interveners was given enough time. I mean, wasn't part of our timeline, but was allowed to file this motion with it, all their points. So that's why I made the motion.
Okay. Commissioner Cabral, did you wish to say anything on this?
My feeling is that unless there's a reason, I mean, I think that we want to be sure we always respect all of the parties involved, and when they need to have additional time or need to have a situation changed, if it's within our power or legally allowed, then I'm typically agreeable to trying to be nice starting the new year. Thank you.
Okay. There's so much one could say in response to that, Commissioner Cabral.
Right, but you're being nice, right?
Commissioners, we are in discussion on the motion before us, made by Commissioner Wong and seconded by Commissioner Cabral. Does anybody wish to discuss the motion? If not, Mr. Ordenker, will you please poll the commission?
Thank you, Mr. Chair. The motion is to grant the intervener's motion for leave to file response to motion for protective order. Commissioner Wong.
Aye.
Commissioner Cabral.
Yes.
Commissioner Giovanni.
Aye.
Commissioner Axon.
Yes.
Commissioner Okuda.
Yes.
Commissioner Chang.
Aye.
Commissioner Ohigashi.
Yes.
Chair Schreier.
Aye.
Thank you, Mr. Chair. The motion passes unanimously with 8 votes.
Okay. We are on to our 5th and final order of business on this agenda slated for 2 days, the petitioner's motion for protective order. I will triple check. Is there anybody in the audience who wishes to testify on this matter, which is the petitioner's motion for protective order? If you are calling in via phone, it's supposed to work that you can press *9 to raise your hand. Otherwise, there's supposed to be a raise your hand function in Zoom, which from the indications of one public testifier and one commissioner may have disappeared in a software update. I hope not. But is it still there? Is somebody able to raise their hand at all?
This is Bianca. It does appear that you can raise your hand, but only as a panelist. I'm not sure if the attendees have that.
Okay. I as the co-host of the meeting from electronic version, I'm not able to do it. Commissioners, I want to make sure, are you able to? We have not come across this before. Okay, yeah, I see some hands going up. Okay, thank you. Okay. Okay, so any public testimony on this matter? Seeing none, I believe we will first hear from the petitioner.
Thank you, Mr. Chairman. Petitioner requests a protective order to protect what petitioner believes is highly confidential personal financial information. We believe that certain of the information contained in the full credit agreements submitted to the commission in response to the commission's request contain confidential financial information that would effectively place the petitioner at a competitive disadvantage in obtaining additional financing if this information were made known to sources of potential financing. We have no objection to disclosing the fact that the commissioner did obtain these lines of credit, but we would like to keep the terms of the credit agreements confidential. That's essentially it.
Okay. Are there questions for the petitioner? Starting with Commissioner Okuda.
Thank you very much, Mr. Chair. Thank you, Mr. Ewan. I'll try to speak directly into my iPad. If for some reason you can't hear me, please stop me, because somebody commented that at some point they couldn't hear me. Mr. Ewan, just to give you a slight heads up, my questions that I'm going to be asking will fall into two areas. The first area is whether or not the protective order is permissible under Hawaii law based on the current record. And the second part is the practical effect if the protective order is granted. So just so that we're clear, do you agree that protective orders that would be issued by a government agency like the Land Use Commission must be specific and not overbroad?
I would agree with that statement.
Okay. So can you again, so that we're very clear, what is the specific information that the petitioner wants kept confidential? Is it simply terms of loans, or can you specifically state what specific information the petitioner wants to keep confidential?
It's the terms and conditions of the various lines of credit that the petitioner has arranged in order to develop the project. The fact that the commissioner has obtained these lines of credit, we've disclosed that, and that can be disclosed to the public, but the terms and conditions of the credit agreements themselves, we would like to keep confidential.
Okay, and when you say the terms and conditions of these various credit agreements, can you be more specific about what terms and conditions you want or your client wants kept confidential?
The interest rates charged, the covenants that the petitioner must comply with, the events of default, basically all of the essential business terms of the credit facilities.
Would you agree or disagree? Well, let me just ask first what we all call the closing question. Besides what you just described as far as the terms and conditions that your client wants kept confidential, are there any other terms or conditions which your client wants kept confidential?
I suppose I would have to mark up the credit agreement, if you will, to indicate what I would want, exactly what I would want to be kept confidential. But I would say essentially it's all of the various affirmative covenants and negative covenants, the interest rates, conditions of draws, events of default.
Okay. Besides those items which you have described, are there any items that you can give a description which your client wants kept confidential?
That sums it up.
Is it true or not true that if your client applies for other or additional financing or replacement financing, a lender could demand as a condition of providing or evaluating or underwriting a new loan that these documents be produced to the new potential lender?
A potential lender could, but the petitioner could also decline to submit the documents, and have the new lender judge the petitioner's financial condition based on the information the petitioner provides to that lender.
Okay. Do you believe that this information which you want to keep confidential or which your client wants to keep confidential is relevant in any way in determining whether or not your client, for example, has the financial ability to move forward with this project? And when I use the term relevance, I mean it as defined by the Hawaii Rules of Evidence, a fact which makes a matter of consequence either more likely or less likely. Is the information which you want to keep confidential, which you just described, is it relevant to determining whether or not your client is financially able to carry out its representations which would be made to the commission and to the community?
No, because the fact that the petitioner has obtained a particular credit facility it has been disclosed, and I believe that's sufficient on which the commission can base its decision as to whether the petitioner has the financial ability to undertake the project.
Okay, so now I'm getting a little bit confused, because if this information in the petitioner's view is not relevant to an issue that's going to be before the Land Use Commission, why would the applicant submit it in the first place? And let me tell you the reason why I'm asking the question. It's like the applicant is creating on its own a problem and seeking a solution for a problem which, if the applicant says this information is not relevant, then the applicant need not submit it based on the applicant's view of the law and procedure in the first place.
The reason we submitted these credit agreements is because we were asked by the commission to do so. We didn't do it voluntarily, but we disclosed their existence in the petitioner's financial statement, which the petitioner submitted to the commission. We then received a letter from the executive officer requesting the submission of the two credit agreements.
Okay, then let me follow up with this question. Is it totally impossible for the credit agreements not to be relevant to determine whether or not the applicant has the financial ability to proceed with whatever it's applying for?
I believe the existence of the credit agreements and the fact that the petitioner has obtained credit from third-party sources is relevant, but the terms and conditions under which the petitioner has obtained credit, I don't believe are relevant to the commission making its decision. I think the commission can and should consider the fact that petitioner has obtained financing from independent third-party sources to proceed at least through the pre-development stage, but the next stage, the terms and conditions under which petitioner has obtained this financing are not necessarily relevant to the commission's determination.
Well, is it true or not true that terms and conditions, in fact, provide evidence about how firm or how much really of substance the loan or credit facility is? Example, isn't it true that there's a difference between a loan for, let's say, $50 million due in 30 days versus a loan of $50 million due in 2 years?
I suppose that would be relevant depending on what the purpose of the loan is.
Well, for example, if I, Gary Okuda, and I assure you I do not have $50 million, am an applicant for a developer, and I'm trying to tell you, Mr. Ewan, lease me property from a client that you represent. I assure you I have the ability to build the development, and you won't face a mechanics lien because I don't pay my bills. But if you find out that my loan is for the terms and conditions of my loan is $50 million due in 30 days and not $50 million due in 3 years where I can take out permanent financing, the difference in the term would be material and relevant to you making a decision whether I would have the financial ability. Would you agree that that could be a fair and reasonable concern?
Not necessarily, because I think what's relevant is the fact is somebody's willing to lend you $50 million is whether it's for 30 days or 2 years, once the lender hands you that $50 million, the lender has to be have some reasonable assurance that you're going to repay it.
Okay, okay, let me move on.
Commissioner Okuda, I'm going to do a time check because we might take a break at some point. Do you have a bunch more?
Yeah, maybe a slight bunch.
Okay. A small bunch of bananas. Okay. If it's okay with the parties, it's 9:57 a.m. I'd like to take a 13-minute recess and reconvene at 10:10 a.m. And we'll continue with questions from Commissioner Okuda, followed by questions from Commissioner Ohigashi. We're in recess till 10:10. Commissioners Cabral and Chang, are you available?
Sorry, Mr. Chair, I'm here.
Okay, great. Okay, it's 10:10. Petitioners Council, Mr. Ewan, we're still waiting for. I'll start on the record. I'll just note that I was encouraged to glance at national news. Things are hairy in the nation's capital, and whatever individual tradition you might come from, you might at least hope for everybody's health and safety for what's going on there. Okay, Mr. Ewan is back. Let's continue with the questioning of Mr. Ewan by Commissioner Okuda. And I guess the last thing I'll say in transition is I'm glad that we are modeling how one can take care of thorny policy issues in a thoughtful and respectful way. Commissioner Okuda.
Thank you, Mr. Chair. Thank you very much, Mr. Ewan, for your indulgence of answering my questions. Do you agree that the Land Use Commission must make its decision based on specific evidence and not necessarily conclusory statements?
Mr. Ewan, you're muted.
I'm sorry. Yes, Commissioner.
Okay, so what specifically in the record, or what evidence is there specifically in the record which shows that your client actually suffered prejudice from releasing the information which you want protected, or specific evidence showing a substantial risk or a real risk of prejudice? And let me be more specific. For example, I don't see any declaration of any expert or loan officer or business consultant stating that, based on their education and experience, release of this information creates any type of prejudice, or I don't see any specific evidence showing other instances where release of this information has led to specific prejudice. Can you point to anything in the record which shows specific evidence demonstrating the existence of this risk of harm or risk of prejudice based on other similar events?
There is the declaration of the manager of the petitioner that the petitioner would or could suffer prejudice should this information be disclosed to the wider community. No events have happened as of this date, but that doesn't mean the petitioner will suffer prejudice in the future.
Okay, I read that declaration. Would it be clearly erroneous for me to come to the conclusion that that's a conclusory statement or a statement which is speculative?
Well, speculative because the petitioner is concerned about future harm. The harm has not yet occurred, but the petitioner has a long way to go to develop this project, and the kinds of financing that petitioner will have to secure by way of a construction loan has, you don't go out and get your construction loan until you're ready to construct, and there's no, petitioner is not in a position to do any construction until after petitioner has secured approvals from the Land Use Commission and county zoning. So we're a long way off from that point, and there's no telling what or how this disclosure may come back to haunt the petitioner in the future.
And I see your point, but would I be wrong to conclude that at this point in time on this record, one could reasonably describe this as speculation? Because except for this stated concern, there's no specific evidence showing that there is this existence of harm. I mean, would I be wrong? I mean, reasonable people could disagree, but would I be wrong to conclude that this is really just speculation?
Well, it's speculation at this point in time because one can't predict the future, and one can't predict how what would happen, say, 2 years from now when petitioner goes to try to obtain a construction loan, and how this disclosure may 2 years in the future affect petitioner's ability to get that loan in the future.
Okay, let me move on to another question here. Once the petitioner submits this information as part of its filing, is it true or not true that the information, the documents become a government record, as that term government record is defined in HRS Chapter 92F?
It becomes a government record, but the government agency that has this record may apply procedural safeguards to this record.
Okay, and Chapter 92F, and that's specifically Chapter 92F-11, basically states the starting point for government records, which is essentially that government records are to be, and I believe the term that's used is, quote, open to the public, close quote. Do you agree that that's the starting rule or point of HRS Chapter 92F?
Yes.
And 92F has a section that lists the type of government records where there's an expectation, for lack of a better word, of privacy, which the government is supposed to keep private, correct? And that would be the list in, for example, HRS section 92-F-14. Isn't that correct?
Yes.
But that section specifically states that these protections are limited to records of individuals. And that specific word individual is used. Would you agree?
I'm looking up 92F.
Yeah, maybe take a look at 92F-14. (92F-14) is titled Significant Privacy Interest, semicolon, examples. And subparagraph A says, disclosure of a government record shall not constitute a clearly unwarranted invasion of personal privacy if the public interest in disclosure outweighs the privacy interest of the individual. And then subparagraph B states, the following are examples of information in which the individual has a significant privacy interest. So my question is, isn't it true that this section, which deals with release and non-release of a government record, deals with records of an individual?
To the extent the financial information involves a personal guarantee by an individual, the 92F-6 would tend to support a request to keep that information confidential.
Yeah, and I would agree possibly with that, but my question is a more general question, that the protection under 92F regarding non-disclosure of certain records would be limited to, under 92F-14, records of an individual. That's the term that's used, individual. Would you agree?
It does refer to the term individual. However, I could direct your attention to the rules of the Natural Energy Laboratory of Hawaii, which is a sister agency of DBED, in which the agency is authorized to keep confidential information which is related to a competitive position in a particular business or field of endeavor of potential tenants to seeking leases from NELHA.
Yeah, and I'm going to get to that in a very fast question, but I just want to just make it sure we're talking about the same thing here. I'm only asking about 92F-14, that the protections regarding government records under 92F-14 is limited to individuals. That's what it says on the face of the statute, correct?
Yes.
Okay, and if you look at HRS 92F-3, individual is defined as a natural person. Would you agree? 92F-3, there's a definition of the word individual, and the statute says, quote, individual, close quote, means a natural person.
Yes.
Okay. So when it comes to protection of government records, there's nothing in the statute that says that there's a protection of a government record with respect to a corporation or an artificial entity, correct?
Under 92F, no.
Okay. Now, you cited a couple of Hawaii Supreme Court cases in your brief. One was the Shopo case, and the other one was, do you think that person's name is pronounced Breedy? Is it B-R-E-D-E? I'm sorry, let me get my notes up here. I'm sorry, Brendy, B-R-E-N-D-E. And you cited the case Brendy versus Hara, H-A-R-A. That's 113 Hawaii Reports at 424, a 2007 Hawaii Supreme Court case. And you also cited the State of Hawaii Organization of Police Officers, SHOPO, that's S-H-O-P-O, versus Society of Professional Journalists, University of Hawaii chapter. That's a Hawaii Supreme Court case in 1996, found at 83 Hawaii 378. Besides those two cases you cited, do you know of any other Hawaii Supreme Court authority which supports the request that you are making regarding the protective order?
No.
And these two cases did not deal with the protection of corporate financial information being submitted as part of an application to a government agency, such as the Land Use Commission, for a government entitlement or benefit like a boundary amendment, correct?
They did not apply to these cases did not involve boundary amendments.
Yeah, in fact, these two cases dealt with the rights of individuals to maintain privacy for, yes.
Commissioner Okuda, about how much longer?
5 minutes, Chair.
Okay, thank you.
So, Mr. Yuen, these two cases dealt with the protection of individual privacy interests, not protection of information which a corporation is submitting to a government agency to gain a benefit from the government agency, correct?
The petitioner is not a corporation, it's a limited liability company.
Okay, I shouldn't have said a corporation. What I mean
But
is
it's
an
comprised
artificial.
of individuals.
Yeah, but a corporation is owned by individuals too. So maybe I should be more specific. These cases that you cited did not deal with an artificial entity, which is seeking protection for information which it's required to submit to the government agency, correct?
That it does not deal with artificial entities, no.
Yeah, so it's reasonable to come to a conclusion. I'm not saying you're totally wrong, but a reasonable person could conclude that the cases you cited really might not support the relief you're requesting, correct?
Well, it's the closest we could find, Mr. Commissioner.
Okay. And then let me ask you finally the practical question about how this protective order would work as a practical matter. The protective order states that a party can label information as confidential, correct?
Correct.
And the stipulation says that if the information is labeled confidential, there's certain procedures that parties would need to follow, including the signing of a declaration where whoever receives the information promises not to disseminate the information, so forth and so on. Am I fairly stating part of the procedure that the stipulation contemplates?
That's correct.
Yeah, you know, one of the things that I think the Land Use Commission can be proud of is the good work of its staff to try to give transparency to the community on what goes on in the commission, along the lines of doing things like everything that comes into the commission is posted to a website, to the Land Use Commission website, so that the public has access to all the information. Whatever we as commissioners see, the public sees. How does your stipulation address the fact that if something is submitted to the Land Use Commission, it's posted on the website?
We would ask that certain portions of the agreement be redacted from what's posted on the website.
Okay, but your stipulation also, or stipulated protective order, would also restrict parties who gain access to information that is, or documents which are stamped confidential, to carry out certain duties. Do you expect the public as a whole to be bound by what is stated in the protective order?
About all we can do is expect that certain information be redacted, but we can't control what someone who accesses the commission's website does.
Okay. Do you agree that if your stipulation is adopted by the commission, there's going to be some practical problems about posting this information and giving public access?
Well, I think it would be a simple matter to withdraw the credit agreements from the commission's website and redact them and repost them.
Okay, and this, I promise you, is my absolute final question.
Okay, I will hold you to it, Commissioner.
And you can, because I wanted to end my line of questionings with this. And my question to you, Mr. Ewan, is I'd like to read the preamble purpose section of 92F, which is specifically HRS 92F-2. And it does recognize the right of individuals to have protection of private interests. But tell me whether or not this really should be the guiding principle, and whether or not the commission approves the stipulation or approves it in part or denies it. And let me quote this, what the legislature has said. In a democracy, the people are vested with the ultimate decision-making power. government agencies exist to aid the people in the formation and conduct of public policy. Opening up the government processes to public scrutiny and participation is the only viable and reasonable method of protecting the public's interest. Therefore, the legislature declares that it is the policy of this state that the formation and conduct of public policy, the discussions, deliberations, decisions, and action of government agencies shall be conducted as openly as possible, and the statute that deals with access and openness to government records follows. Did I accurately read the statement of law there?
I believe you did.
Okay, thank you, Mr. Ewan, for answering my questions. Thank you, Mr. Chair. No further questions.
Thank you very much, Commissioner Okuda and Mr. Ewan. Commissioner Ohigashi, followed by Commissioner Chang.
Yeah, Mr. Ewan, I'm just looking at your submittal on page 4 of your proposed stipulation or it's a proposed order. And I'm looking at number 11, that it says the terms of this order do not preclude, limit, restrict, or otherwise apply to the use of documents at the commission hearing. So I'm supposing that even if we redact them, that interveners are free to use it at the commission hearing and it'll become public anyway? Is that what the stipulation reads? That's my.
I think if the redacted information is produced, they're free to use the redacted information.
Well, what I'm trying to get at is that the document, the order doesn't prevent the use of the unredacted documents.
If the documents are submitted into evidence, I do not intend to submit the credit agreements into evidence, though.
But if you have but they may be used in cross-examination, wouldn't they? And wouldn't they be permitted to be attached as an exhibit to be used in cross-examination?
I don't intend to introduce them as exhibits.
Number 11 is just I'm not sure of how it would work or how it would support your position that we should have certain portions of that document redacted. The second question that I have is one that's been bothering me. You know, we practice in court and we know that confidential information is subject to in-camera review, and for somebody to make a recommend or the judge determine whether or not it meets the burden of that test of whether or not it's prejudicial to one party versus they would do the balancing test on those issues. Is there any procedure that you would be willing to submit to that would have that kind of in-camera inspection done by maybe the chairman of the commission? Make that determination.
Well, that would be a suggestion we could accept.
Knowing that each side would set out you would provide the redacted portions that you are requesting, and I'm assuming that the interveners agree to some kind of mechanism where they would keep it confidential for the purpose of making submitting arguments on those reacting to the chairman for him to do an in-camera inspection of it. That's what I'm thinking.
I suppose that would work.
I don't have any other questions.
Thank you very much, Commissioner Ohigashi. Commissioner Chang.
Thank you, Mr. Chair. Mr. Ewan, just a few questions. you would agree that the financial condition and the ability of your client to proceed with the development is a critical consideration by the commission in moving forward on this boundary amendment. Would you agree?
I'd agree.
Okay. And could you just confirm with me that your client obtained this property through a foreclosure action?
My client purchased the property at a foreclosure sale. That's correct.
Correct.
We were not, my client was not the foreclosing lender.
Okay. And that your client obtained a commissioner's deed for this property. Is that correct?
Correct.
So it's not a warranty deed, but a commissioner's deed.
Correct.
Okay. And you would agree that the granting or denial of this motion is really the discretion within the discretion of the Land Use Commission based upon balancing, all of the different considerations, both the privacy interests of your client versus the ability of your client to proceed with the project. Would you agree that that is within that the ultimate decision is within the discretion of the commissioners?
Yes, I'd agree with that statement.
All right, thank you very much. I have no further questions, Mr. Chair.
Thank you very much, Commissioner Chang. Commissioners, are there further questions for Mr. Yuen at this time? Oh, Commissioner Wong. Sorry.
No problem, Chair. Thank you.
I'm not used to you being so small.
That's my wife said that.
I'm going to put you on mute. No, go ahead, please, Commissioner.
Anyway, morning, Mr. Yuen. I got a question for you. I just want to make sure I have everything in my mind correct. So the docket itself is about a DBA, correct, Mr. Yuen?
I'm sorry, could you restate the question?
The issue that's going to come in front of us is about a district boundary amendment. Is that correct?
Correct. Yes.
So I know there's the main issue is a protective order about financial conditions and statements and et cetera, correct?
Yes.
So let's say the county OP or the intervener says to you or your client, hey, I want to see all the financial statements. Could you at that time also say, no, I don't want to, and let the LUC and explain why? And the LUC can then determine that just at that point in time?
Well, the LUC rules require the submission of a financial statement, and we did submit a financial statement. What is at issue is after we submitted the financial statement, we received a letter from the executive officer requesting certain credit agreements.
Statement wasn't it?
Okay, so that portion, or you, from what I gather, when Commissioner Okuda was asking, is mostly about you want to either redact the terms or not even show it. Is that correct? That's the only portion you don't want to show.
That's correct. But we acknowledge that the financial statement itself is part of the Land Use Commission requirements, and we submitted it.
Okay. That's all. I just wanted to make sure I have everything correct in my mind before we continue on this. That's all. Thank you, Mr. Yuen. Thank you.
Thank you, Commissioner Wong. Commissioners, further questions for Mr. Yuen at this time? If not, we'll hear from the County of Kauai.
Thank you, Chair. Just a couple of follow-ups. Mr. Yuen, are you familiar with HAR 15-15-50C? So when a petition for boundary amendments are submitted, it must include a statement describing the financial condition, right?
And we did submit the financial statement, yes.
And as part of that, it has to be a clear description of the manner in which the petitioner, your client, proposes to finance the proposed use of the or the development.
We have recited in the petition and supporting papers that the petitioner intends to obtain a construction loan to finance the proposed development at the appropriate time.
Okay. And is it your as part of your request that things that you mentioned, like the interest rates, the terms and conditions of the loan, and the conditions of default, that should be kept out of that clear description of the manner of the fund?
Correct.
Okay.
And the fact that the petitioner has obtained this pre-development financing speaks for itself.
Okay. And is it your claim that information falls under 92F-14?
We believe it falls within the spirit of 92F-14, but to the extent it's not a financial information of an individual, then technically it may not.
Okay.
You know, Mr. Chair, this is Commissioner HoKua. I'm sorry to interrupt, if I may.
Yeah, please, Commissioner.
Mr. Chair, my observation is I thought the parties would make their presentation that one party is not supposed to cross-examine another party.
I was a little bit taken aback and was.
I apologize. There's nothing further. I'll wait for my presentation.
So this is your time for your presentation.
Okay. Well, the county position is that it's concerned that, or has interest in reviewing the financial documentation, all conditions of it, so that it can verify that not only are the resources there, but the financing to guarantee construction of the project if it's ultimately approved under the submitted the incremental plan, as well as the 10-year timeframe. And so it does appear that the interest rates or the terms and conditions fall under any of the 92F-14 privacy standards, and they certainly, it does not seem to outweigh the public interest in that information. And the county's unclear how there would be a competitive disadvantage, as cited in the motion, in obtaining a construction loan. So I'll submit for the county under that.
Okay. Are there questions for Kauai County from the commissioners? Mr. Okuda?
Thank you very much, Mr. Chair. Question to the county. Did the county sign the stipulated protective order?
Not to my knowledge, no. Was not.
Okay. Thank you, Mr. Chair. No further questions.
Thank you. Commissioner Chang.
Yeah, so just a point of clarification to the county. Are you opposing the petitioner's motion for protective order? I'm not clear.
It's the county's position that if the commission believes that the privacy interest outweighs the public's interest, we'll submit on that. But the county does have an interest in whether or not that the interest rates, the terms and conditions, that's enough to outweigh the public interest in knowing, and for the county to know how this project, if approved, is going to be financed and or completed in the proposed time limits.
Okay, so one final question. So the county would agree that it is within the discretion of the Land Use Commission to balance the privacy interests versus obtaining all the necessary interests to serve the public's best interests in whether to on this particular boundary amendment, that is within the discretion of the Land Use Commission whether to grant or deny this motion.
Oh, you're muted. You took yourself off mute or on mute from unmuted to muted.
No, I'm sorry. I'm sorry. Yeah, Commissioner, yes, that's the position of the county, the Land Use Commission. Thank you for the question.
Thank you. Thank you very much. I have no other questions.
Thank you. Commissioners, further questions for Mr. Donahoe? So just to be clear with our procedures, we've heard from the petitioner, we've heard from the county, we'll now hear argument from the Office of Planning, followed by argument from the intervener. The commissioners will be given the chance to ask each of the parties questions as to their argument. I'll give a last bite at the apple for the commissioners to ask further questions for clarification, as well as for a brief final statement from any of the parties, and then we'll go into deliberation. We still will go for a little while till we take our next break. Any questions on that? Okay, let's hear from the Office of Planning.
Thank you, Chair. So the Office of Planning had previously agreed to the stipulation for protective order, but since that time, we've done a further review and we have withdrawn our support for the protective order. And we basically take no position on petitioner's motion. Thank you.
Thank you, Ms. Apuna. Always taken aback at the brevity of some of your argument. Are there questions for Ms. Apuna from the commissioners? If not, I will subject you to a little questioning, Ms. Apuna. Because you appear in every single docket that's before us. Is it been your observation that in other dockets, the financial ability of a petitioner to execute on a project has been an issue? Have you seen that occur?
No, I have not seen that occur yet. No, I have not.
You've never seen us have an issue with whether or not, a concern with whether or not a petitioner is financially capable?
Oh, no, I'm sorry. I didn't understand the question. Yes, I think that the commission has seen instances where there were issues with the petitioner's ability to finance the proposed project.
Do you think that when the commissioner, as Commissioner Chang explained the balancing considerations that we have to go to, which if I properly understood some of the extensive questioning of Mr. Yuan by Mr. Okuda, that there was some agreement that there's a balancing test that we have to go through. Do you believe that our experiences in other dockets where we've seen petitioners unable to financially complete projects should be part of our consideration in the balancing?
Yes, I think that could be part of the balancing.
I don't have anything further for you. Are there any other questions for the Office of Planning? Seeing none, Mr. Collins or Ms. Isaki?
Thank you, Mr. Chair. Well, I'll try to be brief. The motion raises claims protection under Article 1, Section 6 of the Hawaii Constitution, as well as the Hawaii Rules of Civil Procedure. It's our position that the type of information that's protected by Article 1, Section 6 of the Hawaii Constitution, it does not, at least the informational prong of Section 6 does not apply in this instance. In Brende versus Hara, which was previously cited, the Supreme Court noted that highly personal and intimate information includes medical, financial, educational, or employment records. But as the petitioner concedes, the information being sought is commercial information, and that is not included within the statement of the Supreme Court in Brende. Instead, they rely upon the Hawaii Rules of Civil Procedure, Rule 26E, for the protection for commercial information. But as the Hawaii Rules of Civil Procedure state, it applies to proceedings in the Circuit Court, not in the Land Use Commission. And the Land Use Commission has not adopted a rule adopting the Hawaii Rules of Civil Procedure. It's our contention under HRS 92F14, which the Land Use Commission must consider because 92F imposes a duty on all state agencies to make their records as open as possible. It's our contention under 92F14 that petitioner is not a natural person, and so there is no balancing test. There is no significant privacy interest under Chapter 92F. So the Land Use Commission has no discretion in making a balancing test because there is no significant privacy interest for a limited liability company under 92F. That being said, if the Land Use Commission were to close government records to the public, applying the balancing test that is for individual significant privacy interests, that decision would be immediately challengeable by any individual of the public. And I think also, you know, as a policy matter, the reason why intervener is opposed to closing these records is because, you know, the financial status of the petitioner is highly relevant to these proceedings. And if that portion of the proceeding has to be closed to the public, then if the public is unhappy with the decision, then there could be an inference that intervener was somehow, you know, participated in this closed door proceeding with all of these secrets that shouldn't be secret. And so, you know, unless there's a competing interest to the public's right to know, it's, I think, to everybody's protection in this deliberative process to keep this information as open as possible. But of course, under 92F, it's required, and there is no exception for a limited liability company. And if the commission were to consider whether or not this information is relevant, of course, our position is that it is relevant. And I would like to draw your attention, maybe some of you remember far back to 2008, when credit was being extended to people and the terms of the credit to purchase homes, a huge difference between prime lending and subprime lending. The variance of the terms of those and whether or not the individuals getting that credit were creditworthy based on those terms caused the entire global economy to collapse. So it's not just the existence of credit which is relevant to somebody's financial abilities, but it's also the terms of those credits, highly relevant. Our global economy, you know, came to a standstill because of the terms of people's credit for their home. And that's like a highly regulated industry with very standard terms. Commercial credit is not, I mean, it is highly regulated, but it's not, this isn't like there's like three choices in terms of terms. It's like every commercial credit document is basically a new one, unless it's, you know, like a consumer credit. You know, so the terms are very, very important to properly evaluate whether or not the petitioner has the financial ability to actually do this, or if this isn't just some you know, paper way of making money by getting an approval from the commission. Finally, you know, the intervener does have a due process right to this information, regardless of whether or not if it's kept confidential from somebody else. But again, under 92F, there is no significant privacy interest. There's no balancing test for the Land Use Commission to do under 92F. We do not believe that the informational prong of Article 1, Section 6 applies in this instance. There's no case law that supports that, and that the Hawaii Rules of Civil Procedure don't apply and have not been adopted by the Land Use Commission. Thank you.
Thank you, Mr. Collins. Questions for Mr. Collins, starting with Commissioner Okuda.
Thank you very much, Mr. Chair. Mr. Collins, the recital that you just gave about the meltdown of the mortgage industry, that's your argument, but there's nothing in the record which evidences what you just cited or what you just argued. Isn't that correct?
There is that there was a mortgage meltdown in 2008, or?
No, the causes of it. And this is the reason why I asked the question, is you may or may not be aware. In my other life, my law firm does a lot of mortgage foreclosures. And in fact, my partner was asked by the legislature to testify at the Hawaii legislature even before the meltdown. And there really is a difference of opinion of what led to it. So the same standard that I was trying to impose or ask that Mr. Ewan follow, which is point to something in the record. I think in all fairness, it should apply to everyone. And there's nothing in the record or evidence on which you base your argument. Isn't that true?
Well, to the extent that this is a proceeding about a district boundary amendment, no, there's nothing in the record that refers back to all of the various things about the 2008 financial meltdown. And yeah, actually, probably a more direct cause of it would be the securitization and packaging of and credit default swaps and stuff. Yeah, I totally agree. But under that are these subprime versus prime mortgages and them being treated equal when in fact they're not. And so it's more of an argument than trying to prove, saying that these two things were different, but they were treated the same and basically became a cause of the meltdown. I'm not asking you folks to make a finding that happened in 2008. I'm basically using it as argument.
Yeah, I just want to make sure our argument is limited to what we have in the record. Now, let me ask you this. Even though 92F has a specific definition of individual and a section that deals with protection of information dealing with individuals, is it your contention, and if it is, what is your legal citation to indicate that artificial entities under Hawaii law have no privacy protections?
Well, as to 92F-3, the definition of individual means a natural person, and the definition of person means an individual, corporation, government or government subdivision or agency, business, trust, estate, trust, partnership, association, or any other legal entity. So we cited OIP opinions that have interpreted this, and I think under the general principle of the inclusion of one is the exclusion of the other, and other principles of statutory construction, when individual means natural person, and then the definition of person means an individual and a bunch of non-individual legal categories, that those non-individual legal categories are excluded from the definition of individual, at least under the statute.
Okay, but I'm asking, and I understand your argument there, but is there, for example, a Hawaii Supreme Court case which specifically holds that artificial entities do not enjoy a privacy protection or a right to privacy? We can debate about what the scope of that right is, but is there a Hawaii Supreme Court or appellate case that flat out states an artificial entity enjoys no privacy protection?
Sure. So I think there's two parts, a two-part answer to that. The first is that the rule that the Land Use Commission adopted said that a party can obtain a protective order for information if it's protected under 92F or by other law. So the burden is on the petitioner to show under 92F that they have a right or some interest in closing it. And under 92F, only individuals have a significant privacy interest. So the question is there other law that does that? And our contention is no, there's no other law that confers on the petitioner a right to submit this information but keep it from the public. So it's not our burden to find a Supreme Court case that says that does the negative. It's the petitioner's burden to actually provide a law saying that they can close the proceedings. So that's our answer, that the rule very specifically gives the standard for which laws should be considered. And under 92F, there is no interest, and petitioner is not presented another law that the LUC has that is subject to that would provide that protection.
Yeah, and I'm not going to belabor this point. My question was just, can you point to an appellate case that says we don't have to worry about a corporation's argument it has a right to privacy? Okay.
Right, and our answer is that it's not our burden, and there is no case law that they've provided that says there is. So.
Okay, so is it your contention that the Land Use Commission, for example, could force the applicant to provide like a bank account number, which if revealed might lead to identity theft or unlawful, improper access to that bank account? I mean, if the corporation has no rights to privacy, wouldn't we have the power if we decided to use our discretion? Hey, produce these bank accounts so that we can verify you actually got money in the bank account. And that information would be made public. Everybody can see the account number, the bank routing number. And even though there's a risk of harm of identity theft, too bad you're an artificial entity, so you don't get any protection. Is that your contention, or does the Land Use Commission have the discretion to draw the line someplace?
Well, I think, I'm not entirely clear under the LUC's rules, what would be the basis for asking for bank account numbers or routing numbers. I definitely think that the LUC under its rules would be allowed to ask for, possibly deposit and debit information from a bank account, but I'm not exactly sure what authority the LUC would have to ask for a bank account number.
Let's say that I convince my fellow commissioners that, hey, we don't trust the applicant. I'm not saying it's Mr. Ewan's client, but the applicant, we don't trust their representation to even have this banking relationship or money in that bank. So we want the account number. We want it stated so that we might issue some type of subpoena, to get the records of that specific account. And if the artificial entity has no right to privacy, then under 92F, the way I understand your description of it, that gets out to the public too. I mean, is it your contention we have no discretion to draw the line to say, in the exercise of our discretion based on the evidence presented to us, we're not, even though it's theoretically possible to get that information under the law, we're not going to allow it to be done as a discretionary event?
Well, the instance of this motion is being brought under a specific rule, and the rule is under 92F or by other law. And under 92F, limited liability company does not have a significant privacy interest because it's not an individual. So the question is by other law, and that other law has not been identified by the petitioner, who has the burden under the LUC's rule to determine that. So I don't know, under hypothetical, I don't know enough information to be able to answer it. I do think that there are other, I think there's a question about whether or not the LUC could ask for things like a bank account number and then publish it on the LUC's website. But I'd have to see what would be the power of the LUC to ask for that bank account number. Because then if it, maybe the LUC doesn't presently have the authority to ask for a bank account number in the manner that you're suggesting.
Okay, that was just an extreme example. Thank you, Mr. Chair. Thank you, Mr. Collins. No further questions.
Thank you. Commissioners, further questions for Mr. Collins? No? Okay. It's 11:04. I'm going to suggest that we take a 10-minute break, reconvene at 11:15, and I think that within 40, I won't close off things, but I think within 45 minutes or so before lunch, we'll be able to conclude proceedings. I'm going to offer each of the parties couple minutes to make any final statements before, and allow for a last round of any burning questions from the commissioners to any of the parties before we go into deliberation on the motion before us. Does that sound like an acceptable procedure? Folks, okay? Okay, it's 11:04. We will reconvene at 11:15. I will first, oh, Mr. Ewan, you're hanging from the ceiling. Quite According to, there we go, much better. I've heard it's good for your back. Commissioners, are there any final questions that you have for any of the parties? If not, I'm going to give each party, starting with the petitioner, a couple of minutes. Commissioner Giovanni.
Just a point of clarification. I'm a little confused about whether or not we asked for the general public, whether they had any comments on the last motion, the current motion.
We did twice. At the beginning, I indicated I was going to take testimony on any of the matters on our agenda. And prior to the start of this, I did a final check to see whether or not there was anybody who wished to testify on this motion.
Thank you, Chair.
Thank you. Thank you, Commissioner. I just as a final aside on this, because some people are able to easily access the various features of Zoom, including raising hands and things. I would hope that when the Office of Information Practices not only is drafting laws on how to deal with our new hybrid or all online meetings, it would be great if OIP did trainings for the public on some of these basic things to further enable them to meaningfully participate in the way that we have to do business at this time. That said, any other questions for any of the parties at this time? If not, I'll give each party a couple minutes to do some closing and then we'll go into deliberation, starting with Mr. Ewan.
Thank you, Mr. Chair. Petitioner submits that while the request for a protective order may not fall under the petitioner submits that while the request for a protective order may not necessarily fall under the strict bounds of Chapter 92F, petitioner submits it's within the discretion of the commission to grant the protective order, and petitioner submits that the disclosure of the fact of the credit agreements is sufficient. Frankly, it's premature for the petitioner to seek construction loan financing so that the ability to produce, say, a $100 million construction facility is just not something that the petitioner or any other developer could obtain at this stage in time. The petitioner will will introduce other testimony to describe the petitioner's financial condition and ability to obtain the necessary financing at the hearing. Thank you very much.
Okay, thank you. County.
Thank you, Commissioner. Thank you, Chair. It does not appear that the interest falls under 92F-14 under HRAR 15-15-50C, which it does require a clear description of the manner in which the petitioner proposes to finance the proposed use or development, which the information that is included in the petitioner's request. It's the county's position that the county, the privacy interest is not outweighed by the public's interest in the disclosure. So it is in the discretion of the Land Use Commission to weigh the factors, but the county does have some interest in releasing this information to the public. Thank you.
Thank you very much. Ms. Apuna, Office of Planning.
OP has nothing further to add. Thank you.
Intervener.
We just, as stated before, that under 92F, the petitioner doesn't have a significant privacy interest. The Hawaii Rules of Civil Procedure don't apply in this context. And that Article 1, Section 6, they've identified no law that would suggest that the information they seek to keep confidential is of a highly personal and intimate nature to satisfy the Section 6 requirements. that the LUC has a duty to have all of its government records open unless one of the exceptions under 92F apply, that the information within these credit agreements are highly relevant. And I just also note that because the Office of Planning and the County of Kauai are government agencies, if they are in receipt of this information and the LUC does not have the authority to make this information confidential, they have an independent duty under the statute to provide the information that they would receive to the public that asks for it. So to the extent that the LUC does not have discretion to make this information confidential, both Kauai and the Office of Planning have independent statutory duties to provide this information to the public, and LUC doesn't have the authority to override that independent duty. Thank you.
Thank you, Mr. Collins. Okay, commissioners, we have the motion for protective order in front of us. We have heard public testimony on this matter, arguments, and we've had the opportunity to question the parties on their arguments. We may enter into deliberation. Does anybody want to discuss this matter and or make a motion? Sorry, Mr. Ewan, are you there?
Yes.
Okay. Okay. Not that you, well, you should be here for this, but okay. Commissioners. This is an unusual day in all sorts of ways, certainly at the national level, where I continue to be concerned. Commissioner Giovanni.
I move to deny the motion for a protective order.
A motion has been made to deny. Commissioner Cabral, you are seconding it?
Yes, yes, I will second that motion.
Okay, a motion to deny the motion for protective order has been made by Commissioner Giovanni and seconded by Commissioner Cabral. I will call on the movant and the seconder to speak to their motions.
Thank you, Chair. I concur with the position of the intervener and the arguments that he's presented, and I come down on the favor of transparency in the interest of the community.
Commissioner Cabral.
I'm of that same mind, and I want to thank my fellow commissioners for their elegant legal positions. I'm of the feeling that when you enter the game of development, if for lack of a better word, and I'm not a lawyer, so I'm a private citizen in business, and I typically prefer government that governs least governs best. But in the case of this type of situation, when you decide you're going to buy this property under whatever circumstances, the rules and the regulations are all clearly printed, and you should enter into it, and you should be ready to meet those bars of requirements as you move forward. So I don't see that there's any massively extenuating circumstances, and it appears there's no legal standing for us to make an exception. And I'm also concerned that if we make exceptions, we set precedents to have to make those exceptions or changes every time we turn around for everyone. So I would agree with my fellow Commissioner Giovanni in denying this request. Thank you.
Commissioners, we have a motion before us. We are in deliberation. Commissioner Okuda.
Thank you, Mr. Chair. I join in the motion, and an additional reason is the fact that I believe whatever action the Land Use Commission takes, especially on restricting access to information on which decision is being made, that decision by the Land Use Commission has to be based on specific evidence, not speculation, and not just argument of counsel. So I do not agree with a position that an artificial entity enjoys absolutely no protection. But given the fact that the public policy, as reflected in the first sections of Chapter 92F, but also as stated in the various appellate cases, is for transparency, is to allow the public access to look at documents and allow that to be part of the meaningful participation in a democracy. I do not believe that the petitioner at this time has met its burden to limit what the legislature has basically set forth as the starting point, which is transparency and openness of government. So for those reasons, I will be voting in favor of this motion. Thank you.
Thank you, Commissioner Okuda. Commissioners, we are in deliberation.
Chair.
Commissioner Wong.
Yeah, I'm going to tell you the truth. I'm in a quandary right now, and I'm still thinking about this motion, just because I believe that companies, organizations does have privacy issues, especially in terms of going forward to get some sort of terms, other monies. However, there is the public issues that they should know they have rights also. So right now, I have to tell you the truth, Chair, I am in that quandary, because I don't know if in the future the petitioner can come up and say, we would like to just redact this portion of our financial statements. Or I have that issue because it's a yes or no right now. We don't have a maybe, or you can have a portion. So I just wanted to say that's where I am right now, Chair. Thank you.
Thank you, Commissioner Wong. Commissioners, we are in deliberation. I will, perhaps to prompt discussion, I will echo that with Commissioner Wong, I'd like to say that I'm not 100% one way or the other. And I share in Commissioner Okuda's observation that I don't think that a non-individual entity is completely bereft of privacy concerns. But I'll say what I'm thinking about right now, and why I encourage and hope for informed discussion from my fellow commissioners to help us decide. One observation, somewhat tongue-in-cheek, somewhat not, is that we all disclose a lot of information just to be here. Like, we disclose, we show you our underwear to be able to serve on this commission. We have to file our yearly disclosures and say who we're getting paid by and how much we're getting paid within ranges and what kind of loans we have out there. So it would be disingenuous to say that that doesn't sort of inform my approach on how we should do business in front of the commission. I'd also say that, like, just as an orientation, part of my orientation to questions like this is that the LUC really is around to help sustainable, good development occur while protecting public trust resources. And the interest in, I just want to be really clear, the interest in disclosure is not to punish business and not to punish developers. But we've seen in so many cases, I have seen in my 6+ years, many cases where the petitioner said, oh yeah, I have this capability. And then it was clear that they did not have the capability whatsoever. And we want good projects to succeed, but they can only succeed and follow through on commitments when we know that there's some level of financial capability of actually seeing the project through, and particularly the financial means to follow through with any representations that might be made in the main part of our deliberation on this. And so those are the kinds of considerations that I think of when we deliberate these matters. Commissioner Chang.
Thank you, Mr. Chair, for sort of invoking some discussion on this matter. I guess over the last several different dockets that we've been hearing, we have seen parties come in requesting changes to original DBA approvals and conditions. Because one, I think at that point in time, when the decision was made based upon representations, primarily regarding their financial ability to proceed with the project, and communities relied upon that, certain conditions were made. So we today have inherited those conditions. And in hindsight, we're now asked to kind of look back and what did they mean? So I think we have the opportunity at this time to do the record right, to ensure that the petitioners who come before us to do projects, to change ag land to urban land, even if it's for affordable housing, that they are doing this, one, they may believe that they have the financial ability. But what we also need to ensure is that the community feels a sense of trust based upon transparency, based upon full disclosure, that the developer likewise has the ability to proceed. We have seen in this particular docket, there is a lot of community interest in this project. So I think it is incumbent upon the petitioner to really consider that this is an opportunity to, sort of proactively address those community concerns, including the financial ability. We have seen over our period of time as land use commissioners, those projects that have had community support based upon robust community engagement have come to the commission with and been well received. So I think the petitioner has an inclination of the community's concerns here, including financial ability. And I think as a commissioners, we also have a responsibility to not only make a decision for today, but a decision that should be able to withstand for the next 10, 20 years. So based upon that, I really believe that the full financial disclosure on the ability of this developer, this owner, to fulfill all of the representations that they are making is critical to the Land Use Commission in ultimately making its decision. So for those kinds of reasons, I am going to support the motion. And if at the time Mr. Ewan brings forward a witness that there's particular confidential information, we can also address it at that point in time. But at this point in time, I think it is important for both the commission and the petitioner to have full disclosure so that the community has a sense of transparency and trust in our own process. Thank you very much.
Thank you very much, Commissioner Chang. Commissioner Ohigashi, followed by Commissioner Axon.
I'm like Commissioner Wong. I'm kind of like in a quandary. I want to make sure that, the way I understand it is that the petitioner is saying, we just don't want certain information to be released to the public. The interveners and all other parties, to ensure compliance with their financial ability, can have this information. So parties to this proceeding can have the unredacted information to make a determination and to prepare themselves to for the purposes of the issue of financial ability to complete the project. So the question then turns is that interest to keep it quiet, is that sufficient enough to keep it from the public? And so I don't view this issue as whether or not they have the financial capability to finish the project. That issue will be litigated and everybody would have the necessary information to litigate it. The question turns is whether the public should have that information. And it appears to me that number 11 that I referred to will give them, number 11 in this the proposed order. We'll give them the information eventually. That's why I'm in a quandary. I'm not sure whether or not we are keeping this information from the public. We provide the protective order at this point in time. And whether or not those information contained there will be available, given the fact that condition 11 allows them to use any party to use the documents within the contested case proceeding. So that's where I'm standing right now. That's all I have to say.
Thank you, Commissioner Ohigashi. Commissioner Axon, followed by Commissioner Okuda.
Thank you, Mr. Chair. It's really very unfortunate that the decision today is just up or down. There's no really compromise. There's no really, center where it's very left or very far right. So my issue on this one is really, I don't know how much Land Use Commission is entitled to any of financial information. Like, Chair mentioned about during our confirmation, they ask how much, but they don't ask what is your account number, or, they only ask where is the bank. So that is really my, my issue right now. I don't know how much we can ask. Unfortunately, the petitioner didn't really, the motion is kind of broad. We don't really know how much or what else he wants privacy. Secondly is, we might be jeopardizing this project because of that. Because as you know, on financial transactions, there are certain, well, it is competitive. The bank to bank, they compete with each other. And maybe sometimes a bank would say, we want this confidential. So what do we do with that? If the financial institution says, you cannot disclose this because Bank A or Bank B, might use it against us. So I'm just hoping that when the time comes, Land Use Commission would revisit again how much information we would, allow the public to know versus, what information we can keep, confidential, or just maybe among just the commissioners, but not in public. So, having said that, I'm still kind of debating what are my positions on this one. So,
Thank you, Commissioner Axon. Commissioner Okuda.
Thank you, Mr. Chair. I think Commissioner Axon and Commissioner Ohigashi raised important points. And that's why, even though I'm supporting this motion, my commentary in questioning Mr. Yuen was, to what extent is what's being presented to us speculative? I believe that since the movant, the petitioner has the burden of proof and the burden to justify imposition of a protective order, the burden rests with them. And reason why I do not believe they're entitled to a protective order at this point in time is because we are being just given speculative situations about what may or may not occur. And just to make my position clear, I'm not saying that if the petitioner were to come with clear evidence of clear evidence of a detriment or harm in releasing certain information, that I would not vote in favor of giving some type of protection. So I believe the problem here is the fact that we're not being given specific evidence of specific situations which require specificity about protection. The other point I'd like to raise again is the fact that the petitioner can always come back to us, and it's within the petitioner's control to determine what they want to present and what they don't want to present. And I do share a concern that Commissioner Chang has been raising about the fact of compliance, ultimate performance of conditions. It very well may be that if a petitioner does not provide sufficient financial support, but the Land Use Commission, exercising its discretion, decides to vote in favor of a boundary amendment, a condition that we might impose is one of a performance bond. And maybe we should just require and impose performance bonds across the board. And the bottom line is, okay, if you don't want to present evidence because of confidential information, that's fine. The representation is being made by the applicant or the petitioner. They have the ability to perform. We won't go beyond that representation. You just make sure you post a performance bond, because then if the affordable housing, for example, is not built, the roads aren't built, the bridge isn't built, well, you know what? We won't chase any lender's representation or anything. We'll just ask the various counties to execute on the performance bond. So I'm still in favor of this motion, because the motion doesn't preclude the petitioner from coming back and asking for specific relief. And number two, it doesn't preclude us from imposing a requirement of a performance bond in the future. Thank you.
Thank you, Commissioner Okuda. Commissioner Axon, followed by Commissioner Giovanni.
I fully agree with the Commissioner Okuda's suggestions about performance bond or coming back to us later on. That's what I said earlier. I'm hoping they can come back later. But my struggle is the motion doesn't say that. The motion, whether we deny or not, it doesn't say, on this motion that, Land Use Commission can impose, require those things that Commissioner Okuda mentioned. So that is really my dilemma. The motion doesn't reflect all those. We're saying maybe this, maybe that, but once you vote on this motion, that's it.
Commissioner Axon, if I may, when you say that the motion does not consider these things, are you referring to the motion filed by the petitioner or the motion made by your fellow commissioners?
By my fellow commissioner.
Okay, so I believe, and I would invite, to the degree that it's not privileged communication, our Deputy Attorney General to opine, but I believe that if, for instance, we were to vote to the motion before us was supported, the discussion has reflected a willingness of the commissioners to consider more specific motions in the future, as well as other remedies to address these issues. And in our own rules that govern LUC procedure, the petitioner is not prohibited from filing a further motion later, even if this motion is denied. Do I understand that correctly, Mr. Lau?
That's correct.
Okay. Perhaps that gives you some comfort, Mr. Axon. Commissioner Giovanni.
Thank you, Chair, and thank you for saying a few of the things that I was going to attempt to say. My motion clearly is a denial of the motion that's been presented by the petitioner, which in my view is a very general catch-all type of a motion to protect his financial information that might be of value to this commission as it determines the wherewithal of the petitioner to actually execute on the project. And as we have all experienced in recent hearings and dockets, and you're hearing from my fellow commissioners, concerns about the representations that have been made before this commission in the past about the financial capability of developers to follow through on projects, only to learn that that was not the case. And now we're having to deal with those troubles that have been created by those representations which did not prove to be true. I think this commission does need to look forward to things like performance bonds to help assure that the projects will go forward. I also feel that if we go forward with my motion, it does not foreclose the petitioner from coming forth to protect in the future, or to ask this commission to protect in the future specific information that does compromise their privacy. And finally, I do not accept the petitioner's argument that by divulging details of which he indicated were the specifics that Commissioner Okuda asked for relative to the project development money that they have secured to date, which probably represents on an average less than 10%, in many cases less than 5% of the total amount of money that would be required to actually execute these projects. I don't accept those arguments that those specifics, if they are made public through this commission's hearing, would in any way jeopardize the ultimate ability of the petitioner to secure the other 90% of the financing plus that would be required to execute the project. So I am reaffirming my position to deny this motion. Thank you.
Thank you, Commissioner Giovanni. I have been swayed by the arguments and believe that no harm would come to the petitioner through denial at this time, and that the petitioner can avail themselves of a future more specific motion, and that the motion from the petitioner as presented to us should not be granted. So that's where I've landed. Commissioners, we are in deliberation. Is there further discussion or deliberation? If there is not, I will ask Mr. Ordenker to poll the commission. Is there any further discussion? Seeing none, Mr. Ordenker, would you please poll the commission?
Thank you, Mr. Chair. The motion is to deny the motion for protective order. Commissioner Giovanni.
Aye.
Commissioner Cabral.
Aye.
Commissioner Axon.
Yes.
Commissioner Chang.
Aye.
Commissioner Ohigashi. Commissioner Ohigashi.
You're muted, Commissioner Ohigashi.
It was on purpose. Reluctantly, aye.
I'm sorry.
Reluctantly, aye was the response.
Okay. Commissioner Okuda.
Yes.
Chair Scheuer.
Aye.
Thank you, Mr. Chair. The motion passes unanimously with 8 votes.
Thank you, commissioners. Thank you to the parties.
I did not hear a vote.
Yeah, what about Wong? Commissioner
Oh.
Wong?
I follow Higashi's reluctantly aye.
Okay.
But I was in mute too, so sorry.
And Commissioner Axon also voted, correct? Yes. Okay. So the motion has passed unanimously. Thank you for all the parties and your thoughtfulness and the agreeableness with which you approach today's business. It stands into sharp relief with the violence that is going on in our nation's capital. So I thank all of the parties. Before I adjourn, I normally ask if there's any further business, and I understand that Counsel for the Office of Planning would like to make a statement to us.
Thank you, Chair. So this is my last time before the commission as OP's Deputy Attorney General. So I just wanted to say thank you so much for the past almost 5 years. It's been so wonderful to work with all of you. You're so thoughtful and diligent and put a lot of heart into what you do. And I've always appreciated coming here each month to work with you all, and you make me laugh too. So I will miss you all, but thank you so much, and hope to see you in the future.
May I question council as to where you are going?
I'm going to DPP. I don't know how official it is, so I probably shouldn't say it in a public hearing, but yeah, thank you.
We look forward to hearing. Any
Chair.
comments, commissioners? Commissioner Wong?
I would like to first thank the council for OP for her time and effort. I should have asked you more questions at this past hearing. So just to keep no comment, but I just want to say good luck. Thank you, and hope for all the best for you.
Thank you, Commissioner.
Commissioner Chang, followed by Commissioner Giovanni.
Oh, Ms. Apuna, I am very sad to see you go. I will tell you, I look to Office of Planning. I mean, you are sort of, in my view, you represent the public, but more importantly, it's also the manner in which you conduct yourself. Besides being very professional, you likewise are very thoughtful, and but yet, but you're also firm. I have greatly appreciated your participation in the Land Use Commission hearings. You have, your participation, in my view, has been quite instrumental. So thank you. I wish you well. I do. I wish you the best. I'm sorry to see you leave us, but I wish you the well. Thank you.
Thank you, Commissioner Chang.
Commissioner Okuda, followed by Commissioner Giovanni.
Thank you, Mr. Chair. If in fact, Ms. Apuna, you are going to a position of leadership and policy, I'm not sorry for you to leave. And this is the reason why. We need people like you at the county level who can see not only statewide big picture, but county issues, but really have the public interest and public trust in mind. We can all differ about what really is in the public interest. We can differ about how our state should move forward, but it's a real tragedy, and it's a real fear when people don't even consider looking at the bigger issues to make the community better and focus just on narrow, selfish interests like, what is it in for me? How can I make it financially better for me? And what is it? Me. So I'm not sorry you're leaving. I'm serious about that, because if you are going to where I think you're going, in the position that I think you're going, I think we on Oahu and the city and county of Honolulu will benefit greatly from that. So this is a positive thing. I'm glad you're going. I'm glad if you volunteered or you were arm twisted into it, that you made the decision. I don't even have to wish you good luck, because you're going to do an outstanding job even without luck. So thank you very much for your service to the commission. Thank you, Mr. Chair.
Thank you. Commissioners Giovanni, followed by Axon, followed by Ohigashi, followed by Cabral.
Thank you, Chair. So Ms. Apuna, I'm the newest commissioner. I've only been on the commission for about a year. And so I was only blessed with one of your 5 years before us. But let me say that you have been the bright light of sanity for me as we have considered different matters along the way.
Not your fellow commissioners.
No, it's Ms. Apuna that has been the bright light of sanity and critical thinking and logic, which I have relied upon for my own judgment making. So thank you for providing that light. And like Commissioner Okuda, I know you will do well. I'm glad to see that you're going to be active and performing in another very important job for Hawaii. And so I wish you well. I know that you will do well, and look forward to seeing you again.
Thank you, Commissioner.
Thank you, Commissioner Giovanni. Commissioner Axon, followed by Commissioner Ohigashi.
Thank you, Mr. Chair. I just want to echo the comments of my fellow commissioners. You will be certainly missed during our meetings. And I just wanted to wish you the best, because there's a lot of work waiting for you where you're going. And I know you're gonna do a good job. Again, thank you for your opinions. I greatly appreciate it. So I wish you the best. Thank you.
Thank you.
Thank you, Commissioner Axon. Commissioner Ohigashi.
My impression of you is that I can make an agreement with you on a handshake. I think you're, and I don't say that to every lawyer that I've met in the world. I find you very honest, and when you give your word, you give your word. And I'm sure that you will take that into your new position. I am sure that Rodney Funakoshi is crying right now because he's losing his best advocate. And I agree with you, Don, that Arnold makes me laugh. So with that, I wish you good luck.
Thank you, Commissioner.
Commissioner Cabral.
Yes, thank you. And of course, I'll echo what everyone else said. But to add to that, I want to say that I appreciate often what I find, which is my specialty, I think, common sense. I'm not a lawyer, so I really appreciate sometimes you do the best job of just bringing it down to putting it in a box that a lay person like me can understand, and showing the this and the that's, but making it at a level that can represent what the law requires. And you make those references, but you've also very clearly made it understandable to, in my opinion, I'm the common woman, common man, and I appreciate that. So I don't know exactly where you're going in the county. I'm going to assume we at the state level will take the loss, and hopefully you can approve Oahu. They need you. So thank you.
Thank you, Commissioner Cabral.
Is there anything further, commissioners? I will join and echo in all of the comments of my fellow commissioners and add just two specific observations. I've been most grateful for your service, Ms. Apuna, when you've disagreed with things that I've said and argued against how I was thinking, and when I've seen you change your position in the midst of dockets in the face of new evidence. And I think those have been incredible strengths. Thank you to the parties on this docket that this today was dealing with for dealing with this additional time that we had, but we want to provide time for sharing our aloha. Thank you to all of you, beginning with Mr. Ewan, Mr. Donahoe, Ms. Apuna, Mr. Collins, and Ms. Isaki for really the best kind of public discussions that we can have. It means a great deal to me, and I think it means a great deal to the state of Hawaii. So thank you all. And if there is no further business, I will declare this entire meeting adjourned. We're not meeting tomorrow. We've gotten through all of our business. Thank you very much.
Hey,
Thank
Don,
you.
Aloha.
leave it, Don.
Thank you, everyone.
See, so who made you laugh? Just joking.
Everybody stay safe. Do not let your guard down, because COVID is still out there. So be careful, be careful. Okay.
Yeah, the next couple months are gnarly.
Yeah, well, I have it at my office. I'm the hotspot of the Big Island. So it's
This
really,
is why you're working from home?
I'm at home, yeah, but it's been 6 days now.
Okay.
So aside from a $2,000 cleaning bill, I have to pay my employees basically to stay home for 10 days.
Okay.
And I have 3 employees with the COVID, and we know where it came in. One of those has been in the hospital. So it's the 21 employees and potentially their family, and it's a massive responsibility. So not a good year already. So be safe, be safe. Okay.
Nancy.
Donna Puna, later on, when everything settles down, I would like to take you to lunch just to say thank you again.
Of course, he wants to have food involved.
Nice to see you, Jody. You have to stop talking so much during our hearings.
I know.
You're in a competition with Rodney.
At least she's visible.
Everyone, thank you so much, Dawn. Best wishes. Thank you, intervener, Mr. Martin.
Thank you.
Good luck, everybody. Okay, Rita, we'll see you later. Good luck with those minutes.
Take
Bye-bye.
care. Aloha.
Thank you
Aloha.
very much, everyone. Yes.
Okay, okay, so